Good morning, everybody. Thanks for joining us today. My name is Kara Corches. I am the interim president and CEO of the Missouri Chamber of Commerce and Industry. We are thrilled to have you with us today on this webinar to learn about the changes to U.S. labor laws. As we see generally about every 4 years, there's an uptick of new labor laws and regulations right before an election year. That's pretty common to see. And so we know that we have received a lot of questions and have been doing a lot of research on hopefully how to inform you of how to deal with these new changes in your businesses. We are want to be a resource for you always as members of the Missouri Chamber. So please never hesitate to reach out to us if you have questions about federal, state, or even local labor laws and regulations. We have a team of subject matter experts here at the Missouri Chamber, one of which is going to lead this webinar today. So I want to first thank our team for putting this together, our communications and events team, Karen Bushman, Megan Davis, and Ashley Schwab. They are making this event possible today. And we are thrilled to be hosted by Phillip Arnzen. He is our Director of Legislative Affairs, and he is our labor subject matter expert in the Capitol and outside of the Capitol in the regulatory arena. So Phillip is going to take it away, but again, just want to thank you for being with us, and I hope this webinar proves to be very helpful for you all.
Thank you, Kara. Appreciate that introduction, and also want to thank the communications team for all their work putting this together. There's a lot more technical stuff in the background that I have no idea how I would even begin to do that. So I want to thank them for getting all of this set up. As Kara said, my name is Phillip. I'm a Director of Legislative Affairs at the Missouri Chamber, and one of my issue areas focuses on labor. And so I know we've had a lot of questions from members, a lot of questions as well from legislators around the state on some of the changes that we've seen in the U.S. labor law in the last few months. So we're going to focus on two today. One is the change in the salary requirements for salaried employees, and then the other is the non-compete ban from the Federal Trade Commission, or the FTC. As a quick disclosure, this is informational. I am not an attorney, and this is not supposed to be legal advice. If there's anything in here where you were kind of on the fence about of whether an employee falls under a certain classification or falls under a certain exemption, I would recommend contacting an attorney, an HR professional, or you can directly contact the U.S. Department of Labor or the Federal Trade Commission. And sometimes they will actually give written guidance that you can use if they decide down the road, we don't actually think that a worker falls under this. You can sometimes get that written guidance and say, no, you told me otherwise. So we'll go ahead and get started. Let's see here. Okay, so a quick background. The Fair Labor Standards Act is what governs the overtime rules, and it was passed originally in 1938 and really formed what is known now as our kind of the common labor and employment laws we follow, the 40-hour work week, minimum wage, and then minors, under 18 prohibits them from working in certain industries and certain jobs. And so this law has been updated dozens of times since then. Some of them are small, such as changes to kind of federal contracting requirements, and others are quite large, dealing with like age discrimination, and then obviously updates to minimum wage and the minimum salaries. So the FLSA, and specifically the overtime and minimum wage laws, apply to all public and private employers. That also includes nonprofits. There are two kind of main exemptions on this. One is private employers in the service and retail business with less than $500,000 in revenue and that do not engage in interstate commerce do not have to follow these overtime rules. However, the interstate commerce clause in there is really going to exclude a lot of businesses under $500,000 in revenue. If you take credit cards or if you have a vendor that's out of state, that's engaging in interstate commerce. So even if your revenue is under the 500,000, you still have to abide by the overtime and minimum salary laws. And then additionally, for some Public employees, typically it's going to be things like first responders and teachers. They don't have to abide by a lot of the FLSA rules. However, there are some other things that do govern the amount of hours worked and that kind of thing. So the big changes we've been hearing about that went into effect on July 1 of this year is the minimum salary requirement for salaried employees. That increased from $684 a week to $844 a week. And then that is going to jump up again in January to $1,128 a week. And that's about a 60% increase, which is a very, very large increase. We believe it could have a pretty detrimental impact to a lot of employers in our state. In less than 6 months, having to pay salaried employees 60% more, or the minimum salaried employees 60% more. It's going to hurt a lot of businesses and could particularly impact our small employers. And then another requirement change is for the highly compensated employees, which we will get into that definition here in a couple slides. That increases from $107,430 a year to just under $133,000 on July 1. And then in January 1, it goes to just over $151,000. And then this is also another part that we think could be problematic is starting July 1st of 2027, every 3 years, that minimum salary amount is going to be increased. It will most likely be increased, and that's going to be based off of the 35th percentile of salaried workers in the lowest wage region, which is the South. Currently, that could change to be a different region. And then for highly compensated, it'll be the 85th percentile. So we do have some concerns there over the automatic adjustment. So there's two quick things to note on this. One is that this is a regulatory change. This is not a legal change. And so the current administration could decide maybe we don't want to have that automatic increase every 3 years, or they may decide, look, maybe we don't want to go through with the January 1 increase, or more likely than not, the next administration could come in January and determine that they actually want to rescind or roll back some of these minimum salary increases. And so that's something to be aware of. As I know there's folks with a lot of concerns, but that's something to be aware of that it could change. And then here I think is another big point is just because you pay somebody the minimum salary, as of now, just under $44,000 a year, that does not mean they are exempt from being paid overtime. You could pay somebody that minimum salary, and if they don't meet some requirements that we're going to talk about, then you still might have to pay them overtime for any hours over 40 hours a week worked. So the criteria for a salaried employee to be exempt from overtime pay is that they must be paid a salary, pretty self-explanatory. They must be paid that minimum salary of just under $44,000 a year, again, explanatory. And then this is where some employers there's some confusion on, and this is where they end up having a complaint, is an employee has to have a job function that is either an executive, administrative, or professional role, and that's known as the EAP exemption, in order for that employee to be exempt from overtime. And so we will get into those definitions. So in order for an employee to meet the executive exemption is they must be engaged in a duty that is primarily managing a large part of the enterprise, managing a department, or managing a subdivision of that organization. They also must oversee at least 2 full-time employees or the equivalent of 2 FTE. And then they must be involved in hiring and firing or other contemporary HR things such as promotions, pay raises, disciplining, that kind of thing. I think a good example of this would be, say, a kitchen manager at a restaurant, because they're managing a large part of the enterprise, the kitchen, the sit-down place. That's about half of what the organization does is cooking. in the kitchen. They oversee two full-time employees. And then they also usually have the ability to, or they would have to have the ability to hire or fire, and then also make recommendations for discipline, pay increases, or other things of that nature. And again, an employee has to meet all of that all of the bullet points within the executive job function in order to uh, be exempted from overtime pay if they meet the minimum salary. So the next one is the administrative. And so I don't particularly like the way they word this, calling it administrative, because it's not, most folks might think that means somebody that's in like a clerical role, or somebody that's, a receptionist or an assistant. While they may meet these requirements, just because they're in an administrative role doesn't mean they're going to meet that. And so the two things, that criteria they have to meet is they have to be the job has to be not manual labor. So, usually in office, and it must be part of the general business operations, or kind of a big part of what the business does. And then that employee must also have some discretion and autonomy in what they do and in their job. I think a good example of this would actually be like my role at the chamber as one of the directors of legislative affairs. One of the things we do at the chamber is advocacy in Jefferson City and our capital. I'm a lobbyist in the Capitol, so I'm engaging in a large part of what our organization does. And then also on my job, in my issue areas, I have a lot of autonomy to determine kind of, what bills or legislation the chamber is, we should be supportive of for our business community, or opposed to for our business community. So there's also some autonomy and discretion in my role at the chamber. And then the final part of the EAP definition is professional. And so this one is usually for folks that are going to be a job that's really technical in nature. It has to be kind of an intellectual job, more traditionally white collar job. It must be in a field of science and learning, and they must have a very kind of prolonged and specific training in something. So it could be a master's degree or PhD, or it could be a very specialized type of training that took years to get. So traditionally, this is going to be somebody that does kind of research and development, or a university professor is going to fall under this professional definition. So another thing to remember again is that in order for an employee to meet an executive, administrative, or professional exemption, they have to meet all of the bullet points within one of those categories. So I mentioned earlier the highly compensated employee requirement. So this one, as you remember, it has a higher salary. So the minimum salary is just under $133,000 a year now. In order to be classified as highly compensated employee and not have to be paid overtime, they only have to meet one bullet point from any of the EAP. So if they make that minimum salary and the only bullet point they meet is that they oversee two full-time employees, then they would be exempt from overtime, even if they don't meet anything else. So it's a much easier threshold to meet. However, the pay is much higher. So there is another exemption, and that is the outside sales exemption. And to qualify for that, an employee must be doing sales, and they must be doing sales off-site. So they cannot be, on a sales floor where, the business operates. A good way to think of this employee is somebody that is doing door-to-door sales, or going to a lot of trade shows, and is not doing sales at the actual place of business. So something to note, we've seen a few exemptions. There are a lot more, but a lot of them are very niche. And most of the folks that do have these exemptions for overtime pay, they're aware of it. We could go into that, but it could potentially take hours to go through all of that. So just be aware that there are some other exemptions, but they're very, very specific and very niche exemptions. So a quick recap, because I know that was quite a bit of information in a short amount of time. So just because an employee is on a salary and meets that minimum salary does not mean they are exempt from overtime. In order to be exempt, they have to be paid a salary, be paid that minimum salary, and meet one of the EAP exemptions or executive, administrative, or professional exemptions, or they fall under the definition of a highly compensated employee making 133,000 or more, and they just have to meet one of the bullet points or meet the outside sales exemption. Um, so the enforcement of the FLSA and specifically the overtime laws. So the Wage and Hour Division within the U.S. Department of Labor is the enforcer of these laws. An employee can file a complaint if they believe they're owed overtime, and this triggers an investigation. There is a 2-year statute of limitations. If it is a willful violation, so if U.S. Department of Labor determines that an employer is intentionally misclassifying somebody, then they can have a up to 3-year, go back up to 3 years. If an employer is found in violation, then they will have to do back pay for the 2 years, or if it's willful, 3 years. And then additionally, if somebody is, a repeat offender, or if they believe they've been just pretty negligent in these offenses, they can do a $1,000 fine per violation. Per violation. And then another thing to note is the Missouri Department of Labor does not enforce the overtime provisions. It is just the U.S. Department of Labor. And I've had conversations with the Department of Labor, and most of the issues is an employer just misclassifying somebody, where they think that somebody falls under one of the EAP categories, and the Department of Labor determined, no, we don't believe they fall under that category. And again, as I'd mentioned, if you have an employee that you think qualifies but aren't 100% sure, again, contact an attorney, HR professional, or the U.S. Department of Labor. They have an office in St. Louis and also one in Kansas City. So the kind of current legal status of the rule, there have been many business groups that have threatened to file a lawsuit, including the U.S. Chamber of Commerce. However, so far, the folks that have are the Plano, Texas Chamber of Commerce, along with about a dozen other plaintiffs, have filed a lawsuit. That is working its way through the court system. There's really hasn't been any indication of where that's going to land or what that's going to look like. Their argument is they believe that the Department of Labor, by having such a large increase, as we'd said, a 60% increase in 6 months, they believe that is kind of not really in the spirit of the law, and they don't believe that the law backs them up with that large of an increase. However, there was one success from the state of Texas. They were successfully able to get their public employees exempt from this increase. So hopefully, with the legal proceedings, for the private sector moving forward, that it will end up kind of more along the lines of what the state of Texas got. But again, we will see. So before moving on to the non-compete rule, I forgot if I'd mentioned it or not, but if you have questions, there is a Q&A box on the bottom. And so you'll put your questions in there. And then at the end, we'll go through those and we'll pull out the questions and do our best to answer them. And then also you'll be able to email me afterwards as well. But again, if you have any questions or if you need clarification, use the Q&A box at the bottom of your screen. So the next is the FTC non-compete rule. So this is the Federal Trade Commission, not the U.S. Department of Labor, but this could still have a pretty big impact on private employers. So non-competes, many folks are familiar with them, but it's an agreement between an employer and an employee when they start working for an employer that really just, if they end up leaving that employer, there are certain restrictions such as you can't take a book of business, you can't go work for a competitor immediately. Most of the laws governing this, they're different, in each state. However, there are some similarities. And at the end of the day, they all have to be pretty reasonable non-competes. So I guess a good example for kind of a reasonable non-compete would be, a firm might say, you can't work for a competing firm for 1 year within 30 miles of our firm. That would be, generally considered reasonable. Um, Again, get an attorney to double check this if you have non-competes. However, unreasonable would be, you can never work in this industry in the country for the rest of your life. That's pretty unreasonable, and most folks would probably agree with that. So what the non-compete change does with the FTC, one, it goes into effect September 4th, and it would ban all future non-compete agreements for entities that are within the FTC's jurisdiction. Employers are also required before September 4th to send notice to all employees that non-competes are not enforceable. They do have some guidelines on that of what constitutes notice, how long, and what needs to be in that notice. And we will send out information after this with a link to that notice to make sure that you're staying within the FTC's guidelines. So there are a couple exemptions for the non-compete ban. The first is that senior executives can continue to have a non-compete. However, if you hire somebody that falls within this definition after September 4th, you're no longer allowed to have a non-compete. But senior executives have to make a little over $151,000 a year, and they have to be in a decision-making position. The other exemption, and I think this is a much larger one, is again, it has to be anybody that is not covered governed under the FTC, and that includes entities like banks, saving and loan institutions, federal credit unions, common carriers, air carriers, and most nonprofits. And that includes many tax-exempt hospitals and healthcare organizations. Here in Missouri, I know a lot of our hospitals are nonprofit, so many of them would fall under this definition and do not have a ban on new non-competes. Again, I would recommend if you think that you fall under the FTC's jurisdiction or don't fall under it, again, I think you'll need to do some research and talk to a professional to make sure that you're not, that you're following the law on this. So the enforcement on this is it will just no longer be legally binding. If after September 4th, if you do fall under the FTC's jurisdiction, you try to sue an employee, a judge is going to throw it out and say, look, these are no longer binding. There's not a legitimate case here. Legal challenges. So there was a accounting firm in Texas that filed a federal lawsuit, and they were granted a preliminary injunction. However, it was very narrow, and there's still a long way to go. However, I do think that there's a little bit more clarity on this case than probably the overtime one. However, we just don't know how it's going to end up. But the Texas case, I think, is a good sign, but we can't be guaranteed for sure. So that was the kind of the updates on the overtime rule and the FTC non-competes. And again, nothing in this is to be considered as legal advice. It's informational. We're happy to answer any questions. But if you have really specific questions or on the fence or think you're kind of in the gray area on something, would recommend getting a second opinion. So if you do have questions, again, feel free to put them in the Q&A box. So I'll take a minute here to go through some of those and come up with some answers. Second. So one of the questions is, who would determine if the employee has the discretion for the second requirement under the administrative exemption? So that would be if the employee's primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So, I mean, part of that is on you as the employer. And then, I mean, at the end of the day, the Department of Labor is going to make that final determination. Um, and something we'll send out after this too, along with the kind of the FTC stuff, is there are, I mean, pages and pages of FAQs and further clarification for what falls under the EAP. And so we'll send those out afterwards. So somebody asked, paid overtime, can this be offset with accrued comp time? I don't believe you can use comp time. One of the exemptions I actually mentioned earlier was with the kind of first responders and teachers. I believe they do have that, but that's under kind of governed under separate law or regs. But no, if somebody works over 40 hours in a 7-day period and does not fall under any of the exemptions, then they do have to be paid overtime. Question is 500,000 in sales for an organization, the minimum threshold for exemption. Um, so that is um, so a business has to have less than the 500,000 in revenue and not be engaged in interstate commerce in order to be exempt from the overtime laws. Yeah, so somebody asked, they asked for more details on interstate commerce and/or third-party transactions. So talking to the Department of Labor, I asked them what qualified as interstate commerce. Really anything where there's anything going on across state lines is going to be interstate commerce. So if you run a credit card or debit card, that's going to a server that is out of state or potentially out of the country. Additionally, if you have a vendor that is out of state or you're emailing with a vendor out of state, then that is going to be interstate commerce. So again, this is really going to be quite specific. It is only going to be service or retail companies that generally are only going to take cash and be, pretty small in what they do. So it's usually going to be your local mom and pop restaurant or mom and pop general store that only has a couple employees. So is the chamber going to be filing suit against the non-compete? And then why did hospitals get exempt but not private business? So I believe, I'm not 100%, but I believe we've at least signed on to a letter opposing it. And I'm not sure about a lawsuit, but I do know that the U.S. Chamber has at least mentioned a lawsuit if they haven't filed one yet. With the non-compete, just doing research on it, I think there is going to be quite a bit of litigation to really determine what is and isn't a non-compete, and then also a lot of litigation just to see if if the rule is even valid. And as far as hospitals versus private businesses, it is only limited to the nonprofit hospitals, and even then, only certain nonprofits are going to qualify. And I don't really have an example of which nonprofits do and don't qualify, but it is not all hospitals. And then as mentioned in the exemptions, it is only going to be private businesses that are governed by the FTC. So banks, credit unions, air carriers, and a couple others are not governed by the FTC, so they will not be subject to this rule change. So a question, where will teachers fall on these new salaries? I believe they are governed, as I said, they're governed by a little bit different laws and rules, the same with a lot of first responders like police and firefighters. And so again, I believe if you have concerns, you should probably talk to, some legal counsel or HR professionals or talk to the U.S. Department of Labor directly. So somebody did comment and say the U.S. Chamber did file a lawsuit against the non-compete ban. So does anybody else? Oh, okay. Any other questions? And also feel free to email me. My email is on the slide right now. I'm happy to do my best to answer any questions, and I'll do my best to try to get back as quickly as possible. The slides will be emailed out, and we will email out some links to the U.S. Department of Labor with some more explanations on the rules. And then also we'll email some links to the FTC website that'll give more detailed information on who is and isn't part of this non-compete ban, and then also how to make sure you notify your employees if you're part of if you do are governed by the FTC. So appreciate everybody joining. And like I said, feel free to email with any questions. Thanks.